Hi, this is Brian Ka with another video to help you pass the California Baby Bar and the bar exam. So we're gonna move on to wills and trusts, and we're gonna start with question one from February of 2012. So in this question, the call of the question is three parts, and it's divided into these questions. Number one, what interests does Dave have? Dave interest access. That's number one. Number two is are B and C likely successful in terminating the trust? Number three are B and C likely successful in suing. So with those three questions in mind, let's read the facts. So Sam is a widower, set up a valid revocable inter vivos trust, naming himself as trustee, and providing that upon his death or incapacity, his cousin, Tara, should be successor and trustee. He did not name any additional trustee. He directed the trustee to distribute the income from the trust annually in equal shares to each of his three children, ABC and Beth and Carol. He specified that at the death of the last of the three named children, the trust was to terminate and the remaining assets were to be distributed to his then living descendants by representation. Okay, so let's assume that this is Sam's trust, right? Sam. Now, this was going to be divided equally among his children and Beth and Carol, right? Now, upon his death or incapacity, his cousin Tara was going to be the successor trustee, right? Sam was also a trustee. Now, at his death, the last of the three death of the last of the three named children, and Beth and Carol, the remaining assets were to be distributed to his then living descendants by representation. So I guess once they die, the trust was going to terminate, and it was going to go to, I guess, the descendants, which will be Aunt Beth or Carol's children. Okay, so when he established the trust, he also executed a valid will, pouring over all his additional assets into the trust. So pouring over is like a trigger word, and we have to remember that there is a type of will called pour over wills. And for this, um, he executed a valid will, pouring over all his additional assets. So let's say that these are his additional assets. And with this pour over will, these assets will go into the trust, right? This means that the trust in the end will act as Sam's final will, since these assets were going to go into this as a pour over will, which means, again, this trust becomes the substitute will in the end, right? So that's right here. This is the substitute will. Okay. 2 years later, Sam died. He was survived by Aunt Beth and Carol. Within 2 months, Dave, aged 25, began litigation to prove that he was also a child of Sam's, although Sam had never known of his existence. So here is Dave, and number one was about Dave. And the question was, what interest does Dave have in trust assets, right? So it's asking whether Dave has any interest in this trust. Now, if Dave was a known child of Sam, it means that basically he would be disinherited. But there's an exception under the theory of omitted child, and that is when if Sam had no reason to know about Dave's existence, he would be considered an omitted child as long as, number one, he wouldn't be considered an omitted child if he was intentionally left out of the will. The second exception is if he was provided for outside. The third exception is when if Dave's parents were provided for in the will. Now, the facts clearly state here that Sam had never known of his existence. So Sam had never known of Dave's existence, right? So the rule is that after the creation of the testamentary instrument, the trust here and the pour over will, if Sam had never known of Dave's existence, he would be considered an omitted child as long as he was not intentionally left out of the will. Here, that could not have been possible because Sam didn't even know of Dave's existence, so he couldn't intentionally leave Dave out of the will. The facts also don't tell us, because he didn't know of Sam's existence, that he was provided for outside of the will, correct? And third, the facts don't state that Dave's parents were also provided for in the will. So, would he be considered an omitted child under these elements? Absolutely. So he would be considered an omitted child. And for omitted child, they get an intestate share, which is per stirpes system, meaning that the family tree of Anne, Beth, Carol, under per stirpes, they're going to get 1/3 of the trust assets. But because Sam is considered an omitted child and he is eligible to receive the intestate share of the trust rather than Anne Beth Carol getting 1/3, there's going to be a split and there's going to be Dave's name there. And instead of each family receiving 1/3, now they're going to get 1/4 of the trust assets. So it ultimately comes down to the question, what interest does Dave have in trust assets? And because we're not given how much was in here, what exact properties were in here, the best we can do is say that Sam, who had never known of Dave's existence, his trust will be split equally among the 4 children, which means that Dave will receive 1/4 of trust assets. So that's how you do question 1. Now let's move to question 2. Now, will B and C successful in suing or terminating the asset? Now, for termination of the asset, the rule is that if Sam was alive, the agreements between Anne, Beth, or Carol, since Dave came in later, A plus B plus C plus Sam, if all these people agreed to terminate, then they could terminate the trust. However, in this case, even though the inter vivos trust was revocable, after Sam died, the trust became irrevocable. And to terminate irrevocable trust, it requires the agreement between A, B, and C plus the main purpose of the trust. Cannot be frustrated. Okay, so let's just end there and read the facts again. So, for 3 years after Sam's death, Tara administered the trust as trustee, right? Because Anne had very serious medical problems and could not work, and because Beth and Carol had sufficient assets of their own, Tara distributed nearly all of the trust income to Anne and little to Beth and Carol. After the court determined that Dave was in fact Sam's child, Dave claimed a share of the trust. Beth and Carol have filed suit against Tara claiming breach of fiduciary duty. Tara has submitted her resignation, and Beth and Carol have sought termination of the trust so that all assets may now be distributed outright to the beneficiaries now living. So that last paragraph says that um, Beth and Carol has sought termination of the trust, but because we went through the roles and we've stated that since this trust, which was a inter vivos revocable trust, after Sam died, that trust became irrevocable. And when the trust becomes irrevocable, it requires A, B, C, and Beth Carol to agree that it's going to be terminated. Plus, the main purpose of the trust cannot be frustrated. So the main purpose of the trust here, right? Main purpose was what? To pay A, B, and C. That was the main purpose of the trust. Now, the out of A, B, C, only B plus C wanted to terminate. So A not present, right? But it requires A, B, and C. So it fails this first element, which requires A, B, and C to agree to terminate the trust. So it already fails their attempt to terminate the trust. Moreover, the purpose of the trust, main purpose, was to pay out A, B, and C. And by terminating this trust, that main purpose will be frustrated. So frustrates purpose. And as a result, since this is irrevocable trust, and again, it became irrevocable once Sam died, right? Even though he created a trust that was revocable trust, right? So it was an irrevocable trust which required A, B plus C, and the main purpose rule. And since it fails both of these requirements, their attempt to terminate the trust will fail. So number two, are B and C likely are they likely to succeed in terminating the trust? The answer is no. Right? The first one, the answer was they will get 1/4. Now we have to do number three, and number three is, let's see, let's erase here. Number three is, will B and C be successful in suing Tara, right? And why are they suing Tara? Let's look at the facts again. So Tara gave nearly all income to Anne, right? Well, and they give you reasons why she did that. It's because Anne had very serious medical problems and could not work, and because Beth and Carol had sufficient assets of their own, right? But she may be kind hearted, but the law requires the trustee to a very high standards of duty of care, right? Not only that, they're held to a very high standard of loyalty to their beneficiary. Also, they have a duty to follow the instructions of the trust. And finally, uh, they must maintain impartiality, meaning she has a duty to follow the instructions of the trust and not favor one over the other. So a trustee of a trust are held to a very high standard. And here, obviously, when it comes to duty of care, uh, she must act as a reasonable, prudent person. And uh, by distributing assets, by giving most of the income to Anne, she not only breached her duty of care, the argument you can make also is that she breached her duty of loyalty. And obviously, the instructions of the trust here said that uh, he directed the trustee to distribute the income from the trust annually in equal shares, right? So failed to follow instructions because this trust specifically said to distribute whatever was in the trust equally among Anne, Beth, and Carol, and Dave came out later. But they're supposed to get everything equally. So, as far as duty to follow the instructions were concerned, obviously that was a breach, right? She even breached her duty to be impartial, basically favoring, was it Anne? And it's understandable to favor her because Anne had very serious medical problems, couldn't work, and Beth and Carol had sufficient assets of their own. But when you analyze the duty of a trustee, those unfortunate events do not matter. And unfortunately, um, when you're looking at from the eyes of whether a trustee was Tara breached her duties as a trustee because she failed to follow the instructions. She failed to stay impartial as to the equal share of the trust. And I guess you can make an argument of breach of loyalty because from the standpoint of Beth and Carol, Tara breached her loyalty to the beneficiaries, Beth and Carol, and as well as duty of care. So number three, after um, analyzing the trustee duties and go and talk about these elements using the facts, you're going to conclude the reasonable conclusion here that we're going to get is that B and C will be successful in suing Terra, right? Now, the question, I'm not sure if it wants us to get into the remedies. And in this case, I don't know if disgorgement is an option because the trustee, Terra, there are no facts indicating that Terra took some of the assets of the trust, but they can surcharge her as well as terminate her position as the trustee. They can ask the court to do that. So with that, I think that we have sufficiently answered 1 and 2 and 3. I hope that this video is helpful to you. I know that a lot of big time, you know, channels that teach the bar exam, they don't really have a lot of information or resources on remedies, and I'm not really sure why that is. But for me, remedies is something that is not very hard, but it is very easy to forget. Like I would master an essay like this, and I would do it like 5 or 6 times. But after about a month, I forget a lot of these nuances. The duty of trustee won't click right away. So I always usually have to look over the outline and refresh my brain on what an omitted child was, what it takes to terminate the asset, the fact that when the trustee dies, a revocable trust ends up becoming irrevocable. Things like that, like little nuances, like the pour over will that we talked about briefly. How when the pour over will instructs the rest of the assets to go into the trust in this case, then that trust becomes the substitute will. The intestate share of omitted child, the rules behind that, and knowing that Dave gets to butt in here and get 1/4, which will probably make Beth and Carol, but that's what the omitted child doctrine is. So yeah, and it's good to know about disgorgement, surcharge. Yeah, and I think that should be it. And as long as you use the facts, plug it into these rules, I think that you'll have a passing essay. Again, I'm not looking to get like an 85. I'd be happy to score a 70, even a 65, if possible. Assuming that my ME scores are presentable, it's high enough. My goal is never to, write perfect essays. My goal is to pass the bar. So I think that I've done enough here to get a passing score, and I hope you do as well. And with that, I appreciate you and thank you for watching another video. And hopefully soon, in the next several days, probably in the next 5 or 6 days, I'm gonna try to do as many wills and trusts essays as possible, so that you can get a lot of value out of it, especially if you're struggling with the subject, and at the same time, so that I can refresh my brain on how to do these questions again, so I can do well in law school, so you can do well in law school as well, and so that we can all pass the bar exam together. All right? Thank you again, and I'll see you in the next video.